All right, the slap heard around the school. We're going to move on to a tenured teacher. We got Matt, he's a 10th year, 5th grade teacher who's also the wrestling coach and assistant football coach. So that always makes it fun because coaching is obviously way more important than teaching. At least that's my experience based at hearings. Matt's wrestling team returns 4 state police winners and a state champ or state place winners.
Got a shot this year.
Some parents have complained about his harsh tone, his Bobby Knight approach with his team, with his 5th graders, and the loud rap music he plays at practice.
Okay, so this is Matt Russell, who's our driver, who loves him some loud rap. So that's hilarious.
On the way back from the building to the modular, the students in line are told to stop at the door and don't open it yet. Matt's standing on the platform, which leads into the building. One student drops his books and is picking them up. The papers begin to blow across the lawn. The student in the front of the line is known to make trouble on occasion. We'll call him Bobby. The student grabs the door handle lever and starts slamming it up and down. Of course he does. Matt's frustrated, turns around and slaps the hand hard and makes contact with the hand and the handle.
So you can see this happening, right? The papers are blowing across. There's nobody else out there to supervise. Matt's deciding, am I going to jump the railing and help the kid with the papers? Or am I going to stop little Steve from trying to get into the classroom when I told him not to?
And so the student immediately begins crying and yelling that his hand hurts so bad. The scene causes several other staff members from inside the building to come out to the modular. Matt, still angry, says, kids these days aren't taught to listen to authority figures. Preach on, Matt. You can get a call from one of the staff members who is called from her cell phone at the scene. As you arrive, Matt is finally calmed down, but the student's still crying and saying his hand is broken.
I just can picture this kid in my head so perfectly.
You know what? This kid knows the system. They know exactly what to say.
Yep. Bobby the drama queen. Okay. You inspect his hand and do see there are red marks from the edges of the door handle lever. All right, so what are we going to do first? The first issue that we always jump to, especially these days, child abuse.
Yeah.
And so do we have reasonable cause to believe that the child has been subjected to child abuse or neglect? I mean, this probably is. I mean, he's been assaulted. And so we're in the better safe than sorry time in society. You don't want to put your license on the hook for failing to. So you address it from a school district perspective. You also have to address it from the child abuse perspective. And so it very well may be that you have to call this into law enforcement with a toll-free number. As an aside, if you want true action, call your local police department. Yep. That toll-free number, it's a number out of Omaha. They don't know your town. They don't know anything about what you guys have going on. So I would call local law enforcement on that.
Well, so here, just one quick point, because we get this question, and I think as an administrator, it's fair to think about the politics. I think you have to. What if we know we need to make a call, but if we call local law enforcement, they might do something because they don't like Matt. But if we call the hotline, they'll never send somebody out because a kid got his hand slapped. It's your choice, right?
Or we'll call local law enforcement because we know that the chief's son was a state wrestler 2 years ago, so we know nothing's going to happen.
You are required to make the report of child abuse. You cannot skip that step. But we understand
but you
the
can
political
pick where
questions,
you call.
right?
Rule 27 reporting, each certificate holder shall report to the commissioner any known violation. And so this requires you to be a lawyer or a county attorney and figure out down below. So you have to report revoked certificates, obviously not this, misrepresenting professional qualifications, nope. But that subsection E, certificated people cannot commit any act of moral turpitude. Child abuse probably is not going to fall under that. Or any felony under the laws of the U.S. or any state. If the child abuse was significant enough, it could be a felony. And so that's something we have to look at. In this case, we're not going to get into the statutes, but this would not be felony child abuse. And so that's just having knowledge of that act being committed. It doesn't require a charge. It doesn't require conviction. It just means it had to have occurred. And we've recently had a case where it seemed like NDE was ratcheting up the expectations of your knowledge about what's a felony and whether it's been committed and whether it's a known violation. So keep that in mind. This seems to be a rather hot issue over at the department, and we're told there will be some sort of guidance issued. I hope that's accurate. It's I think the plan is a frequently asked questions kind of document in plain English. So you'll have a better idea of what am I supposed to report? When am I supposed to report?
The department's view right now, though, is when in doubt, report. And
Yes,
I hate
question.
that, but that's what their guidance is right now.
So I think the reason that what this does and the reason we put these before any of the personnel considerations is think about what has already happened. You've called and told the police on that. Now you've called
Because you have to.
Because you have to. Now, at least the way that I think NDE is reading this stuff, you've now called and made what amounts to an ethics report. It's no different than if one lawyer called another in and said that one did something unethical. That's how Rule 27 applies to educators. So you've now done two pretty major things that you didn't have a choice to do or not to do. And that stuff's probably happened immediately before you even start processing the personnel case. So you want to talk about the community's riled up, Matt's already riled up, but there's nothing you can do to stop any of this stuff from happening.
Yeah, it's required.
I
So
hate that.
You're seeing it's becoming a three-part process in many of these personnel cases. The last part of that is if you have a misdemeanor conviction. So maybe you didn't know it was a felony, or maybe it wasn't a felony. But once there's a misdemeanor conviction and you have knowledge of it, and it's related to abuse, neglect, sexual misconduct, you have an obligation to report that. You don't have a choice.
Do you want to talk about putting in the obligation for them to tell you that they've been charged into the contract?
We do put that, many of you will have a policy that says this. We put it into our form teacher contract that the NSCA is not a fan of, at least one version of it. But it requires them, if they are charged, if we make it as broad as possible, if there's any chance that they're going to be charged with child abuse or they have committed child abuse, they need to let you know. And if they don't, that's a breach of their employment contract. Number one, it's just important for you guys to know if a teacher's committed that kind of act, we have to determine, is this an appropriate person to be in our building? But two, it also goes to the employment purposes of are we going to take action on that? But we don't want you guys to be caught flat-footed. We don't want the board to be caught flat-footed. You should learn about this before you see them on the 10 o'clock news. That's kind of where that comes from. Corporal punishment, as all of you know, it's prohibited in Nebraska in public schools. You can't do it. We had the Daly case where they defined corporal punishment for us, and it hadn't been defined until 1999. Interestingly enough, it was debated on the floor of the legislature, and Ernie Chambers had put this in, and he says, well, you'll know it when you see it. So there was no definition. So it's reasonably understood to be the infliction of bodily pain as a penalty for disapproved behavior. Infliction of bodily pain as a penalty for disapproved behavior. So that's what our definition is. In this case, was there infliction of bodily pain? Yeah, the kid was screaming out and thought his hand was broken. Was it a penalty for disapproved behavior? Yeah, it was. We have corporal punishment. Now, interestingly enough, corporal punishment is not necessarily a mandatory report. There's going to be a lot of crossover, and in many cases, it will be a mandatory report. But just corporal punishment by itself, not, and maybe that'll change at some point. But
I want to jump in with this definition. Mandy and I were just at the activity directors conference yesterday. This is something that I talk to them about every so often, and I'll probably put it in my deck maybe for next year. But I want you all, if you do double duty as the AD or if you supervise the AD, I am really worried about this idea of infliction of bodily pain as a penalty for disapproved behavior. Doing up downs until you learn not to jump off sides, or running steps because you got an unsportsmanlike conduct penalty last week, or you missed that block as the volleyball player, and so now you're gonna have to do push-ups until you can't do them anymore. We don't have a case that says that, but as I look at that definition, the infliction of bodily pain as a penalty for disapproved behavior, I think we need to have our coaches know this. And I've had 2 PPC complaints against coaches for allegations that they were too Bobby Knight-ish. And so I just want you to put that definition in front of your coaching staff so they know this is what the Supreme Court says is corporal punishment.
so what to do first? Obviously, take care of the kid's injury, make sure he's all right, get somebody else involved if that's appropriate. Document the red marks, the cuts, etc. Take pictures, take videos if it's appropriate. That
And you
comes
don't
in
need
very
parent
handy.
consent for that.
Correct. Contact the parents. Be careful of the personnel file confidentiality. We'll show you a slide here in a minute that'll get into that. And that can be frustrating at times when the community wants to know what's going on, the news contacts you and wants to know what's going on, the parents contact you and want to know what's going on. There's some limitations on there. Find someone else to supervise the class and put Matt on administrative leave. Again, you can suspend them with pay pretty much as you see fit when it's appropriate. It's at your discretion. So here's the personnel file confidentiality provision. It basically says the teacher or administrator gets access to their file, and they can give written permission to people to have access to their file. But no other person except school officials while engaged in their professional duties shall be granted access to the file and the contents thereof shall not be divulged in any manner to any unauthorized person. Compare this to FERPA, or the student records exception. FERPA has kind of a similar provision, but the family, the FPCO, the people who supervise that statute and enforce that statute, there's an exception under the rules. If you have personal knowledge, you saw it yourself, that's not revealing the contents of that student's file. That's giving out your personal knowledge. We don't have that same kind of exception here for our personnel statute. And that makes it very difficult. You know, if the teacher says, well, did you suspend him? What are you going to do? You're going to fire him? Well, if we're in the midst, if we've given them notice, we can't tell them we notice of the teacher. That's confidential until there's a board action or a scheduled board action. And so it can be a very difficult situation to be able to relay to people, yes, we're taking care of this, but we can't tell you. And it's one of those things of, you got to trust us. That doesn't often go over very well with communities, especially in smaller communities where everybody kind of knows what's going on, but they want to know what you're doing.
We can say that so-and-so is on leave because they're not in the classroom. Parents are entitled to know who's going to be in the classroom. Other than that, you literally can't say anything.
So the way that I think this plays out is you call the parents, hey, there was something that happened. What are they going to say on the phone? Well, how did he hurt his hand? So it's always a little bit awkward, because if you haven't yet documented, then technically there's no document that exists, but you know the contents that are going to go in that document are clearly what happened, that Matt, the teacher, slapped the kid's hand. So does that allow you to share with them before you document it? Does it tell you that you should call the parents? So those are all questions that I think you should call and sort through. And frankly, as your legal counsel, we're going to ask you things like, well, are these parents going to react? Are they going to overreact? Are they going to underreact in terms of addressing that?
The other thing that I do sometimes is write up a little report to put into the kids file. Now we've created a FERPA protected document, and parents are entitled under FERPA to see the contents of their kids file. And then whatever we put in Maddie's file separate, that's the personnel file part of it.
And remember, whatever you put in the kids file, the parents get a copy of,
Yep.
so they can take that to their lawyer, to the police, to anybody they want. So that's not to, I agree with Karen completely, but practically, practically that's how you get them the information, but that has a significance then if they're going to take that and probably post it on Facebook.
Yep. Oh, 100%. And they're going to take pictures of the kids' hand. That's why you should take a picture, because they will.
Yep.
So here's the statute that talks about reasons for cancellation or amendment. You'll see down there, unprofessional conduct is on the list. I think this obviously would be unprofessional conduct. We also have breach of any material provision of the teacher's or administrator's contract. That's why I like to put that provision in there, that they have to give us notice. So if it happened outside of school, and they don't tell us, that's reason to cancel it.
So anything in there, so when you're looking at, those teacher contracts all say, for whatever reason, we just use everybody still uses this form, first, second, third, fourth, and it says things like comply with every school policy and that sort of stuff.
That's that one.
Yeah, there we go.
Yeah, and so we put those provisions in there, and we can use those against them. I mean, it's a breach of their employment agreement.
So this is how we get committing corporal punishment to be an admission of a breach of their contract, because we've got a board policy that says we can't do it. So even though corporal punishment isn't in the list of the statute for cancellation, you could do it by saying we've got a policy in contract, you agreed to comply with policy.
And you can see this provision, the very last one, subsection J, any conduct that interferes substantially with the teacher's continued performance of duties. This may or may not reach that level. What history does Matt have? Was this the last straw? Has he used other kids? Has he touched other kids? Or was this the first incident? And so those are factors you could weigh to determine whether this is going to interfere with his ability to continue at the district. The procedures will.
Can I, sorry, I want to go back one. So there is an attorney in this state that says you cannot win a corporal punishment cancellation case west of Kearney.
That may be in the slides.
Oh, is it? Okay, so I'll be quiet. Okay, go ahead.
So here's the cancellation process. And again, we put these in here so you can take a look at the statutes. And you can go back and read those when we're done. We'll summarize them here. Here's our summary. So again, it's the same concept as a non-renewal for a probationary teacher, except cancellation is a little different. They get even more due process. You have to give them notice of the alleged grounds for cancellation in that initial letter. In both cases, if they ask for a hearing 5 days before a hearing, we have to give them a lot more stuff. But in cancellation, you even have to go further than that initial notice for a termination or non-renewal. You've got to tell them the alleged grounds.
Now, and we kick around as attorneys, whether that is just immorality, neglect of duty, unprofessional conduct. We, as a firm, think that they are entitled to more. They're entitled to the facts, not just the legal conclusion.
And so we'll put that information in there. Same thing, they have 7 days to make a request for a hearing. The notice of reasons for cancellation, witnesses, exhibits 5 days before the hearing. That's the same where they get, we call that the disclosure letter. That's where they get all the goods about what it is we're going to present in the hearing. The matter is confidential, again, just like it was last time, until a hearing or court action is scheduled. 30 days to hold the hearing. The formal hearing is as follows. So this is a little different than the non-renewal procedure for a probationary teacher. It's formal. By statute, it's formal. The notice has to comply with the Open Meetings Act. The administration board and teacher are represented by lawyers. There's presentation of evidence. It looks a lot more like a court. Again, they're going to look similar, but this statutorily would have to look a lot more like a court hearing. There's cross-examination, and actually, with most hearing, there's some exceptions, but most hearing officers will let the school administration, the prosecution, ask as many questions as they want, and they'll let the teacher's representative or attorney ask as many questions as they want. It'll go back and forth. In a court hearing, really, if you wanted to be strict, it would be direct, cross, redirect, you're done. But we tend to be a little bit softer on that in the personnel hearings. The decision has to be based solely on the evidence presented at the hearing. You can't take in that extraneous evidence. Remember, you have to be unbiased, and you have to only listen to what the evidence is at that hearing. This is a significant difference from the probationary teachers. It's a majority of the members of the board must vote to cancel the contract. So 4 votes on a 6-member board. And so that occurs no matter what. And so what Karen and I have both had hearings here in the last 2 years where the board members, as we said, were disqualified. They were biased. They couldn't be on the board. I had one where one board member was disqualified and one just happened to not be able to make it to that hearing that night. Don't be that board member. But anyway, so we had four sitting board members. We needed a unanimous vote to have that cancellation go forward. And that's the seat it puts you. You can't get 3 out of the 4 votes. You need all 4 votes.
And you need 4 affirmative votes. You can't have a abstention.
Yeah, no abstentions. No funny business. It's 4 votes of yes, I want to cancel that teacher's contract. The board obviously has to reduce their findings to writing and deliver those to the teacher. So consideration, again, call us early. Here's how we process it. We're going to go through, was it corporal punishment or child abuse? Yes and yes. I think clearly the answer to both is yes. We're going to look at his history. I mean, this is not an automatic termination. You legally do not have to terminate, cancel, or non-renew this kind of teacher. We're going to look at the history. I mean, the past good acts do factor into the situation. The past bad acts factor into your decision on whether we're going to keep Matt around or not. Has there been any other misconduct this year? We'll focus on that. But we also look at even further back than that. And again, we look back to, is the board going to support you? What are the funky political issues that are flying around here? Who does Matt know? Who's Matt related to? Who does he go to church with? Who does he rent from? Who did he buy from? All of those kinds of things.
So one quick thing before Karen jumps into her, you can't fire for corporal punishment, West of Kearney. This is why the fact of the matter is, before you start the cancellation process, we have to know what grounds we're going to allege at the hearing. So while with non-renewal, in every case, we review the documents before we'd ever agree that you have a legally sufficient case and issue the letter. But in particular for cancellation, the reason we ask, is there any other misconduct we'd want to bring up, is you have to list all the reasons in the initial letter. So we basically have to make an assessment, not just of whether it's legally sufficient, but how do we want to actually process the case so that it can go in that letter. So anyway.
So there's the quote that I was jumping in to tell my story too early. Tim Thompson, who's a school attorney in North Platte, I took a corporal punishment case to hearing. I don't lose very many of these hearings, so the ones I lose, I'm really bitter and really fixate on. And so we took a corporal punishment case in Western Nebraska, and this teacher was mean to little kids, like 3rd graders. Like if your hair was in your face, she'd pull your hair and roughly put a rubber band in it because she didn't like girls' hair in her face. And 100%, she would spank and slap hands, and she was mean. And I hated this teacher. It made me very angry. And the board in its deliberations said, we agree that she's mean to little kids, but our 3rd grade teacher's really soft and our 5th grade teacher's really soft. So we think we need this mean teacher in the middle. Otherwise our kids will be too soft. That was literally what the board said in their deliberations. And I talked to board members afterwards and they confirmed it. And so Tim says you can't win a corporal punishment case west of Kearney. I don't know if that's exactly true, but look, we don't take these cases to make you look bad in front of your board. We want you to win. And so I think you should consider, are there board members who are going to say, yeah, Matt did the right thing. That damn kid should be spanked at home. Then he wouldn't have the problems at school that he has. Because that's difficult. And I don't know what to tell you, except that your board has that right to make that decision.
But it goes back to Karen's notion that at the beginning, when we say, is your board going to support you? That is probably the most important question.
Yeah.
You obviously have to have done it right, followed all the processes. But if you say no, I think 4 of the members of that board wondered why the heck Matt was even given a suspension or put on leave. Why would you bring that case?
There's a crappy case out of Iowa where a special ed kid was having a meltdown and he like threw himself on the floor and he's like kicking, and so he's basically swirling himself on the carpet. And the teacher, as he was swirling, he was getting closer and closer to the desk. So the teacher thought he was going to crack his head. So she grabbed his feet and dragged him several feet away from the desk and gets rug burns on the back of this kid's, his back because she's pulling him on the rug. And the parents sued for disability discrimination, saying that she had hurt the kid while he was having an issue based on his disability. In this case, that's something else that we would be asking about. The kid that's grabbing the door handle, does he have ADHD? Is he behavior disordered? Does he have a behavior plan about how he's supposed to be redirected? Because even if you can't fire Matt because you don't think your board will support you, this family could sue you for not firing Matt if Matt has not been following the kid's behavior intervention plan. So these issues get real sticky real fast.
I was just going to say, one of the facts that they alleged in that Sergeant Bluff case was the school didn't fire Matt, right? I mean, that literally became one of the primary bases for them to show that the school was discriminating against the kid on the basis of disability. Why would you not fire a teacher that drags a kid so hard? And their doctor even came in and testified that I've never seen any sort of reaction by a teacher that led to these types of injuries. So they'll get people to say whatever it is they need to make that case.
Yeah.